Boulevard, the police say a man was gunned down at 4 a.m. 22-year-old Frank Russell took himself to the hospital, and in speaking to police, his story changed several times, and they can't tell exactly where the shooting happened. The Hamilton County Sheriff's Office is warning of a scam that's been going around. Scammers are calling residents of Hamilton County saying they've been late on a bond payment or missed jury duty, and they have to make a payment over the phone. The sheriff says this is a scam. If it's going on in the Tennessee Valley, it's going on. Nooga Radio AM 1240 and 92.7 FM.
Looking good out there through your afternoon with lots of sunshine. Getting warm. Highs later on near 85 tonight. Increasing clouds after midnight. Could see a late shower storm. Lows lower 60s. Morning showers and storms quickly passing through Thursday. Highs 78 to 80. Back into the 80s Friday. Chattanooga's best kept secret is at Boyd Speedway. Come see the Neesmith Traveling Street Stock Series. Exciting race this Saturday night. For tickets and more, BoydSpeedway.net or Boyd Speedway on Facebook. And I'm Swargene 12 Chief Meteorologist Patrick Orr. On Nooga Radio AM 1240 and 92.7 FM.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
Welcome to Legal Bytes. This is Jim McCoon, your host. That's another Wednesday edition where we try to bring to you, our listener, information that's beneficial to you, legal information on legal issues that you can use in your personal lives and your business lives. And today we have a special for you. I know that many of you that are out there listening to us own businesses or manage businesses. A lot of you are either mom and pop family operations or smaller businesses, and you don't have a lot of guidance and day-to-day compliance issues. And while we all know about workers' compensation and the issues where employees get hurt, there's a bigger picture that a lot of individual businessmen are not aware of, and that deals with workplace safety. So today we have, and it's a treat and a pleasure for me to have one of my dear friends, Mike Mallon, here today. Hello, Mike.
Jim. Hey, Jim. Thank you. Thank you for having me. I hope I can add some clarity to an area that's confusing, and it's a privilege to be here.
Now, for those of you that don't know Mike, you're a local boy, as I understand it, born and raised here in Chattanooga.
Yes, sir.
And Baylor graduate.
That's correct.
I'm sorry you couldn't get a better education by the ridge, but anyway.
Thank you, Jim. I'll try to keep the one syllable words here.
And Mike is a practicing attorney here in town. And years ago, he and I practiced together, but now Mike's over at Miller and Martin. And Mike, as I understand it, you're chairman of the workplace safety group over there. Is that correct?
That is correct. We have a workplace safety practice group, and I do chair it.
Now, workplace safety may mean a lot of things to a lot of people, but actually what we're talking about is something that is governed by federal and state law and a lot of regulators, as I understand it.
Yes, that's correct. And in Tennessee, actually, there's a federal regulatory regime, and there's the state, which is called TOSHA enforcement agency. So Tennessee, gets doubled up on in some regards, and this affects any employer. There's a misnomer out there that if you have 10 or fewer employees, that you're not subject to OSHA regulations, and that's just wrong. Unless you're specifically exempt for some reasons we'll talk about later. Just one employee brings you into the regulations. Okay, well let's talk big picture, because I'm as you know, I didn't get to go to one of these prestigious Chattanooga schools. I'm from South Georgia. So talk very simply to me, what are we talking about when we talk about workplace, and what is OSHA and TOSHA? What does that stand for? Okay, so OSHA is the Occupational Safety and Health Administration, and it's a division of the United States Department of Labor. And 26 states have chosen to implement their own state programs under the audit and auspices of federal OSHA. So it's sort of half and half. And Tennessee is a state program. Georgia is a federal program. So if you're an employer in Georgia and you have an issue, then you're going to deal with federal OSHA. If you have a problem in Tennessee, unless you are an organization like TVA or Railroad or something along those lines, you're going to deal with Tennessee OSHA or TOSHA.
Okay. Well, let me ask you then, when we say workplace safety, what are these regulations doing, and how are they going to affect businessmen?
Well, it's very straightforward. The Occupational Safety and Health Act, and I'm just going to read from it. It says that the goal is to ensure, as far as possible, every working man and woman in the nation a safe and healthful working condition. So
Okay.
what it means is you've got to have a safe workplace for your employees, and that depends. That's a case by case, work site by work site conversation.
But it does not provide for any compensation to the employee if it's not safe.
That is correct. What it provides is really discipline and punishment to the employer for not providing the safe workplace that's required under the statute.
Okay. Now, as a businessman, how do I know whether or not I am complying, and how will the government let me know if I am complying?
Well, how you know you're complying, if it's your business, then it's your obligation, it's your legal duty, not just under the OSHA regulations, but under common law and other statutory laws, Jim, to provide a safe workplace and a safe place premises for your customers and your employees. If you don't do that, there are really four ways that you might find out. One is an employee or former employee might just get mad and call the regulators.
Is that an often situation?
That's one of the two most frequent, is
Okay.
that you have a disgruntled employee who will call and report an unsafe condition. Then you have random inspections, which don't happen very often anymore.
Okay, Mike, hold on a second. I think we've got a call coming in. Hold on one second. Legal Bytes. This is Jim McCoon. Caller, can I help you? Hello? I'm sorry, we can't hear you.
I mean, how dare they tell my business I operate my business? They're not paying my employees. They didn't capitalize my business. A bunch of fascists. I mean, I want to know what we can do to get rid of them. I'll listen on the air.
Right. Well, Mike, as you heard, there's at least one businessman out there that doesn't believe that the federal government or the state government should have any rights to tell him how to run his business and how to establish safety rules in his business, because of the fact that they're not capitalizing his costs and they're not paying his employees. How do you respond to that?
I guess the same way I'd respond to
I'm sure clients say that to you often.
They say it to me in very, very certain terms, and they tell me things that they'd like to see happen, and those things aren't going to happen. The fact is that the regulations are the regulations. They're enforceable, and there's there's a legal structure in place where fines can be assessed and then they can be enforced.
And actually, this comes from a history of the 1800s where we had slave labor. We had, you and I studied in law school about the mills that would burn down and the child labor and all the women who were working, and there was no safety. They didn't have fire escapes. They didn't have ways to get out of their premises. Time and time again, that happened in this nation until steps were taken to try to protect those who couldn't protect themselves if they were going to work, and that was the employee.
And that's how the act started. And you go back to the Charles Dickens novels and what's the adjective Dickensian, which is what we call those kinds of environments still. And that's the reason that the act was enacted. And responding to the caller, I will say that the act has flourished under both red and blue administrations. So I will say that what's happened under the two Obama administrations is more activist than anything I've ever seen. There were more rules, regulations, and we'll talk about some of those maybe before we're done, enacted in the OSHA field. But I think that's pretty much parallel to how the rest of the Obama administration was.
Right. Now, so just from the caller standpoint, if you're a good employer, you will you will maybe not comply with everything, because I will tell you that when a regulator, I do a great deal of environmental work and compliance, and when a regulator walks into your facility, you cannot do everything perfectly because your employees are carrying a lot of this out for you, and there's going to be mistakes made. So, ordinarily we'll get a notice of violation, and the same on OSHA inspection. You can expect usually a violation.
Right. I mean, perfection is, or total compliance is a goal. It's not attainable. If a compliance officer wants to find something, they will. I will say this about both federal and state inspectors in the OSHA field. They are not out for a pound of flesh. They're very busy. Most of the time they spend responding to catastrophic events, and they treat my clients fairly. It may not be the outcome my clients want every time, but I can say objectively that the outcomes are fair. They're for the most part reasonable, and they do listen. And there's even an informal settlement process that's very informal and very user-friendly, where a lot of things get worked out, and the employer 9 times out of 10 becomes a safer, better employer. So that's for the caller's benefit. That's the regulatory regime we have. I'm going to run through those 4 reasons.
Yeah, that's what I'm saying. Let's go back to how we can find out. How are we going to find out? And how is the government going to let us know if we're compliant?
So you've got a disgruntled existing or former employee who could pick up the phone and call. They're entitled to anonymity and to privacy.
And they don't even have to be accurate. They'll just put you in the crosshairs because they're mad and have full of venom, and they want to see you burn a lot of times.
There is no truth test when they call. And then if what they call about happens to fall into what are called special emphasis programs, the regulators have to go take a look. And that's the second way, is a special emphasis program. And that could be fall protection, trench protection, could be chemical hazards. It could be machine guarding. They're just different special emphasis programs that relate to standards. The third way is that there is actually a reportable event. And that means a fatality, an amputation, a single inpatient hospitalization, or the loss of an eye. Those things require the employer to pick up the phone and affirmatively make a phone call.
How long do they have?
If it's a fatality, the new rules, which I teach a lot of seminars, and I still have attendees who feign or appear surprised when I tell them this, and this is the 3rd year these rules have been in effect. A fatality, you've got 8 hours to pick up the phone and affirmatively advise that there's been a workplace fatality. And if it's a close call about whether it was work-related, you still need to call and report it.
Is it 8 hours from the death or 8 hours from the accident?
It's 8 hours from the time of death, because you have 24 hours if it's an inpatient hospitalization.
Okay, so if they get injured, but they aren't dead, so you think you got 24s, and then they pass 9 hours, then you're how do you comply?
Then you've got to call within 8 hours of the time of death, or within 24 hours from the time of inpatient, a single inpatient hospitalization.
Okay.
And where people get confused is the old rule was it had to be 3 inpatient hospitalizations within 8 hours. Now it's a single within 24.
All right. So if something happens at my business and one of my employees has to go to the hospital, I have to report it.
If they are inpatient treated.
Okay.
If they're not inpatient treated, you don't have to report it, but you probably have to record it on your OSHA 300 log.
And we're not talking about necessarily an industry or a manufacturing plant. If one of my paralegals falls in the file room and ends up breaking something, and we've got to take her in, and because of lower back issues or so, she gets hospitalized, do I have a reporting requirement?
I think you do.
Okay. So could apply even to a law firm, to an insurance agency, to a convenience store, to a gas station. It just doesn't matter.
And that's the reporting with a P obligation instead of recording with a C, which a law firm would probably be exempt from.
Okay.
Keeping a log. But if there's a fatality or inpatient hospitalization, then there is a reporting obligation.
Okay, so now we've covered 3. What's the 4th way that we can find out that the regulators are going to let us know something?
Just what everyone is scared the most of, and what doesn't really happen much anymore, which is just a random inspection.
Okay, just a walk-in audit, basically.
We're driving by, and I'm aware of some of those. I've handled some of those that have gone very badly. But yeah, just a random inspection. And in all those events, the first thing an employer needs to do is require credentials, because it has happened that people who are not deputized to people claim that they work for OSHA and they don't. So you require credentials, and then you sit the person quietly in a conference room and you call someone who is experienced in dealing with these kinds of regulators.
Someone like you.
Someone like me. And if the inspector has to sit quietly and wait for 30 minutes or 45 minutes, they will, and they won't complain about it, because they know that's just part of the process and it's part of the employer's rights.
Okay. So we've got these 4 ways that we're going to find out. And so in any of these 4 situations, can we expect, I know on the last one where someone shows up and says, "Hi, I'm from the government and I'm here to help." But on the other occasions, can we expect there to be a inspection of our facility, an inspection of our books, and questions about our protocols and safety procedures?
You can, that's a really great question. And it's a 2-part answer. Yes, you can expect that you're going to be required within 4 business hours, to produce OSHA 300 logs for 3 to 5 years, 3 in Tennessee, 5 federal, probably, but 3 to 5 years of OSHA 300 logs, and the required safety programs that might relate to the injury that the compliance officer is there to investigate. And when they ask for those, the clock starts ticking, and you need to have them, or else you're going to get cited for not having the 300 logs or the safety program.
All right. So what about, I've got a friend that's got a body shop, and it's him, his wife does the bookkeeping, and he's got 3 guys that work back in the back and basically assist in the work that has to be done. They're not going to have OSHA 300 reports and all those kind of things.
I'm sure if they're your client that they already do.
Well, I said they were a friend, not a client.
Okay, good. If you have under, and that's a good nuance when you mention 3. First of all, you a lot of facts in what you just said. Owners are not subject to the act, only employees. So if it were just this gentleman and his wife, OSHA would have no jurisdiction. If it's just owners. Now, the 3 employees are subject to, the employer is required to provide a safe workplace and to comply with all the safe standards that might apply in a body shop, which might be respiratory protection, machine guarding, fall protection, slip, trips, and falls. But since it's under 10 or fewer employees, there's not a OSHA 300 log recording maintenance obligation.
Okay.
Just to make it very complicated for all the listeners. So,
right. Well, that's why I felt like a cancer salesman. We were telling them, you got 4 hours to produce documents. And I'm thinking some of these listeners are going to say, I don't even know what an OSHA 300 is, much less be able to produce it.
And what it is, it's a log of injuries and illnesses that employers who have 10 or more employees, including part-time, over the course of a year, you just pick the maximum, have to keep this log, and you fill it out. And then at the end of the year, you do a summary of 300A. And if you've got 10 or more employees, then you're subject to keeping the log. And there are certain groups of employers who, this was the Obama administration that came in and did this, that they changed, there are some exempt groups that don't have to. So if you're clerical office, you might not have to keep the log. But if you are, here's one for you that ought to really get your attention, spectator sports. And I'm actually having a conversation with an out-of-town reporter right now about the NFL. And I've done some work with Bloomberg News on why is it that the NFL doesn't keep 300 logs.
Interesting question.
Very interesting question.
Yeah, because if they had those, then all the competitive, I assume the competitive teams could access when they're submitted to the government, they could get access to all the injuries that were reported.
That's true if they're not required to be submitted, but that's the next thing we're going to talk about is that the Obama administration, I started predicting in 2013 because a policy came out from the Department of Labor that said that they want anonymous reporting of workplace injuries so to help find and fix problems. And that turned in last year to a real live, full-blown update, which is going to require later this year and then moving into next year, employers to actually electronically submit to a government database their annual 300 logs. They used to just go in your file cabinet. Now they're going to have to be electronically submitted. So
wow.
That is Big Brother
Absolutely
has shown up. Now, as we all know, the Trump administration has put a moratorium on the
most of the federal government, actually.
Yeah, well, yeah, but the Trump administration has definitely slowed things down in terms of how some of these pending regulations are going to be delayed. And the rulemaking delays require things like for every new rule you introduce, you've got to drop 2 off. But there's really no guidance as to when and how. Does it have to be simultaneous? So the one thing that I can tell you is the mood has changed in terms of how aggressive the regulations and the enforcement is going to be toward employers. And I think that environment has now tipped in favor of employers, not in favor of the regulators.
Okay. So from the standpoint of advising a small businessman, such as the example I just gave you, a small businessman, they've got 3, maybe they got 5 employees. They're, a couple of them are part-time. They're barely making as it is, because it's a tough economy still out there, as everyone knows. So how would you advise them to address these workplace safety issues in an efficient and economical manner?
There's 2 words. It's hazard assessment.
Okay.
And I do walkthroughs, and I always tell people who are nice enough to come sit through my seminars, if you'll give me an hour of your time, I'll give you an hour of mine. So anybody who wants to call me and wants an hour of my time, I will offer that hour at no charge, and I will talk to you. And if you don't live work too far away, I'll come look at your workplace. And I do audits, I do inspections, and I look at safety programs and do hazard assessments based on what the workplace seems to call for in terms of what the compliance should be. But as I said when we first started talking, it's case by case. It depends on what the workplace looks like, what is done there, and how it's done. And I can walk in and in 5 minutes probably know more about an employer than they want me to know.
Yeah.
Just like you can on the environmental side.
Right. Or a lot of other issues. Yeah, you're absolutely right. Because we do this daily, we can walk into businesses and we'll see things. And Mike's offer to you is there, and you can reach Mike. Mike, we're competitors in the legal practice, but as far as the best I think around on these OSHA issues, in my opinion, it's you. And you can reach Mike at his office at 756-6600.
That's it, 756-6600. And Jim taught me everything I know about environmental law. So if I'm either a great or poor environmental lawyer, it's all on Jim.
Well, that's because I'm not a good teacher.
Just a good practitioner.
There you go. All right. So Mike, when you do your walkthrough, we were talking about how they can economically and efficiently address these issues. What would you tell them to do?
Well, as you walk through, in my head, I'm thinking about really 12 different areas, and it really lines up nicely because OSHA has a top 10 list of citations, and there's a set of written workplace safety plans, and they all relate to each other. And I'll just run through these. The most frequently cited violations are fall protection, hazard communication, scaffolding, fall protection training, ladders, aerial lifts, excavation, general duty, which is everything that's not enumerated anywhere else, electrical, machine guarding, and then related to that, the plans that I look for an employer to have, depending on what their operations involve, are bloodborne pathogens, confined space, emergency action, fall protection, fire safety, forklift safety, general safety, hazard communication, hearing conservation, lockout tagout, which is electrical, respiratory protection, and workplace security.
Okay. Well, we're to the end of the first half hour, Mike, and this has really been educational, at least for me, and I hope for the listeners. We'll be back after the break. This is Legal Bytes with Jim McCoon and Mike Mallon, our guests, and we'll talk to you after the half hour.
News Talk 1240.
Nooga Radio AM 1240 and 92.7 FM News Now. Multiple shootings rocked the Chattanooga area. A teenager was shot in the Brainerd Tunnel from a passing car while they were both driving. Police are calling it a vehicle-to-vehicle shooting. The gunman still on the loose and the victim in the hospital. A man was shot in the parking lot of the Woodlawn Apartments in Avondale about 8:30 p.m. yesterday. Police say 24-year-old Daquan Jamal Duke in serious condition. The gunman in this case still on the loose. The police believe it was a targeted shooting. And on Rossville Boulevard, the police say a man was gunned down at 4 a.m. 22-year-old Frank Russell took himself to the hospital, and in speaking to police, his story changed several times, and they can't tell exactly where the shooting happened. The Hamilton County Sheriff's Office is warning of a scam that's been going around. Scammers are calling residents of Hamilton County saying they've been late on a bond payment or missed jury duty, and they have to make a payment over the phone. The sheriff says this is a scam. If it's going on in the Tennessee Valley, it's going on. Nooga Radio AM 1240 and 92.7 FM.
Looking good out there through your afternoon. Lots of sunshine. Getting warm. Highs later on near 85 tonight. Increasing clouds after midnight. Could see a late shower storm. Lows lower 60s. Morning showers and storms quickly passing through Thursday. Highs 78 to 80. Back into the 80s Friday. Chattanooga's best kept secret is at Boyd Speedway. Come see the Neesmith Traveling Street Stock Series. Exciting race this Saturday night. For tickets and more, BoydSpeedway.net or Boyd Speedway on Facebook. And I'm Swargene 12 Chief Meteorologist Patrick Orr. On Nooga Radio AM 1240 and 92.7 FM.
McCoon, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal, providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCoon Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Chattanooga's best kept secret, Boyd Speedway. Come see the fastest dirt late model drivers in the South compete for a purse every Saturday night. Pit gates open at 3, grandstand opens at 5. Racing starts at 7. Bring the whole family for a night of fun as they tear it up on the dirt track. Go to BoydSpeedway.net and check out the Dirt Simulator. BoydSpeedway.dirtsimulator.com. Chattanooga's best kept secret, Boyd Speedway. Fun-filled, outrageous racing. We'll see you Saturday night.
The Dirt Showdown #1 with limited late models, crate late models, sportsman, hobbies, street stocks.
Boyd Speedway. News Talk 1240.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
Welcome back to Legal Bytes, your weekly show with respect to legal issues in your personal and business lives and how we can address them. Today, our guest is Mike Mallon. And Mike, we've been talking about workplace safety and health issues. And I guess we were trying to address right before the break that we had the question of how we can efficiently and economically address some of these issues for the very small businesses and alike. And I guess the first question, is there a place on line at a website or something where you could get some of these safety plans you were talking about, or some of these ways to address these issues where it wouldn't cost them much money to at least try to get something on file?
There are, Jim. First of all, there's a free look, and I've got to give the OSHA.gov website credit because it's got a search box, it's got a search engine, and it works very well. And it's a free look, and they've got very good one-page guidance.
All right, Mike, I think we have a call. Let me see if I can get this. Hello, caller. Caller.
Yes, this is Roger.
Hey, Roger, how can we help you?
Got a question about reporting accidents, trying to find out what kind of protection do I have under TOSHA if I report an accident or report what I think is a dangerous condition in my workplace and to keep from getting fired. So
okay.
If I'm a whistleblower, what kind of protection is offered from TOSHA or OSHA?
That's a fair statement, Roger. So you're calling on a scenario where you're an employee. You're not a manager. You're not an owner. You're an employee, and you're aware of a dangerous situation in the work environment, right. And you're concerned about retaliation or retribution from your boss. If they find out you've called and told OSHA or TOSHA there's a problem. That's right. Fair statement.
Somebody's looking out for me, so I want to make sure if I report this that I'm not going to get fired for it.
Okay, Mike, that's a great question.
Good question and straightforward answer. Section 11C of the Act goes to whistleblower protections. And when you choose to call or show up to make a report, or even during an investigation of an accident, give a statement, you're entitled to anonymity. Who you are, your identity is entitled to protection and privacy, and to be redacted if anyone makes a Freedom of Information or Tennessee Open Records request. If you request privacy, it will be granted, absolutely. And in addition to that, if any sort of retaliation is attempted by an employer as a result of an employee exercising his or her rights under the Act, then the employer is subject to whistleblower liability.
Okay, so I just called the 1-800 number for the TOSHA representative here in Tennessee.
Yeah, I mean, every major city has a field office, and the compliance, safety, and health officers that work in those field offices answer the phones. And if there's something that concerns you in a workplace, you have a legal right to discuss that with the compliance, safety, and health officer.
And what I would do,
appreciate that answer.
And what I do, Roger, is I would also probably make sure that they understand that you're concerned about retaliation and that you don't want them to show up at your workplace to investigate what you're reporting, and have it clear that it came from someone like you. If you're the only person in a certain area of your workplace working, so you're the only person would have knowledge of the issue, then you're a dead giveaway just because of the inspection, the way it occurs. So it needs to be handled broadly by the office so that they don't give you away in the way they handle it. And you should probably make that clear to them so that they're aware that there's some eggshells that need to be walked around.
And if you look in most, medium to large size employers, if you look outside the locker room doors or cafeteria area, you're going to see one of these large these are your rights posters. They used to be called five-way posters. I've seen them. Yeah, so that literally expresses in great detail what I just shared with you.
Okay, hey, I appreciate it, fellas.
All right, thanks for the call. All right. Well, that was a good call and good question.
And whistleblower, and actually OSHA, people aren't aware of this, but the OSHA administration structure handles whistleblower hearings for 22 different federal statutes, from Sarbanes-Oxley to Food and Drug Administration.
Wow.
Those are all heard under the auspices of OSHA hearing officers.
Man. So we've got a very sophisticated hearing officer if he has to bring such a claim.
Yes, I mean OSHA complaints are heard under that same regime, but it's just interesting that OSHA became what I call the dumping ground for the federal government for all federal whistleblower claims under federal statutes.
Related to that, is there any type of ombudsman where you can call and say you're an employer and you're not sure if you've got an issue, but you need guidance and you don't have a fine lawyer like yourself or can't afford to pay those big firm rates that you've got, and they've got a question? Is there any kind of ombudsman where an employer or a manager could call and say, I'm concerned about these issues and I need to talk with anonymity so I can try to address them?
There are two ways to do that. I like the way you danced around the big firm rate statement as you were making it. Thank you. OSHA has a consultative branch. They have what we lawyers call a Chinese wall.
Okay.
They have a wall literally between people that work in the field office that are consultative, and they will come see you. If you're over 250 employees, I think they will not. But if you're a small business and you call and you say, I want to talk to someone in consultative, they will talk to you. They will answer your questions. And if you want them to come do a walk around with theoretically no jeopardy, they will do that for you. Catch, I don't know that it's a catch, but I'll call it that, is that if they make recommendations, you're on the hook to do what they recommend.
Despite the cost. If they tell you that scaffolding's got to go, you need to extend that floor, you need to get rid of that ladder, and you need to put in stairs, and the capital cost to you is going to be $20,000. It doesn't matter.
Or worse, engineering controls, like that machine's too loud, it's over 80 dB, and you got to get it down. It's 120 dB, and hearing protection's not feasible, and you've got to get that down, or you've got a respiratory issue, and you've got to suddenly think about newer, different machinery. I mean, there are engineering controls that can be six figures, but the short answer is consultative. And then the way that I usually have my clients proceed is that I work with a series of very qualified safety and health consultants, and their hourly rates are very affordable. And sometimes it's worthwhile to have one of these consultants come in confidentially instead of going to actually to the regulator, and have the consultant make recommendations and get plans up to standard.
Can it be confidential? Is there any duty to report if something's found
by a consultant?
By a consultant?
No, I don't think a consultant has any ethical duty to report.
And once the owner employer is on notice because consultants point out a problem, does he have a duty to report?
I think that's a question that the answer to. If the bad thing happens, then there's going to be this knowledge, pre-existing knowledge issue, which is why sometimes, and Jim, we do this in the environmental field also. Sometimes consultants get hired by law firms.
Right. Exactly. So we can keep the information as part of our work product, and we can determine what needs to be disclosed to the client and what doesn't need to be disclosed, and whether the client needs to have knowledge of certain issues.
That's exactly right. And I mean, and subject to our ethical limitations, that creates some privilege that sometimes is useful.
Right. I know a lot of times, and we still do it to some men in buy sell deals where we got environmental potential issues environmentally. We'll negotiate whether the buyer or the seller is going to do some testing, because one of them has an obligation if something's about them, one of them doesn't.
Right. Yeah. Some report, if you, what can hurt you.
Okay.
So, but if you go back to the idea that you want to have a safe workplace, everybody wins if you can avoid workplace hazards.
Sure. And on the other side of that, you also will probably improve your workers' comp rate, because if you've improved the safety environment in your facility and you have some training teaching your employees how to properly do things, then their injury rates should fall.
That's right. Experience modifiers get better. And when I lecture, I've got a whole section on being proactive versus reactive. And experience modifiers get better. Workers' compensation premiums can improve. And if you've got a clean, compliant workplace, the chances are that employee morale is better than otherwise, and that your product is better than it would be. That's why I'm saying when I walk in, I can tell in just a couple of minutes a lot about culture and about product and about quality.
Okay. Now, for those businessmen that are out there listening, there have been some areas of a special emphasis under Obama and the agency that have not completely been pulled back by Trump yet. Isn't that true?
Yeah, I think there's a lot that's in sort of in suspended animation because there are new rules that are going forward, such as this affirmative reporting every year of, at this point, 300A summaries, and next year 300 logs and 300As for employers over 250 employees. So, yeah.
And again, for those you just turning in, a 300 is basically an incident reporting log. If there's an injury or something happens in the workplace, you log it and onto a form 300. Fair statement, Mike?
That's exactly right. Unless it's first aid, basically, if it's a health or safety issue that caused an injury that requires treatment other than first aid or non-prescription medication at a non-prescription dose, then it's got to be logged.
Right. So much of what you're already doing for workers' comp claims, all you're doing is mimicking a lot of the same information into a log that you'll have for health and safety compliance.
And if the regulators show up for a reason, such as we talked about in the first segment, then you're going to be asked to produce those logs. And by July 1st, 2018, you're going to be asked to submit those electronically to an OSHA database, which is still to be created.
Right. Now, getting back to there is emphasis, don't I recall that ditch digging, something we do every day all over Hamilton County, is an area of emphasis now with OSHA.
Yeah, trench protection actually is, and you hear about...
You can tell I'm from South Georgia. I said ditch digging. Yeah. It's trench protection, excuse me.
Yeah, that's it. the more literate of us in this field of work, if you dig a ditch or a trench that's more than 5 feet tall, 5 feet deep, then you have to set the dirt back. There's a slope requirement that the dirt be set back a certain amount of feet from the edge of the trench, and the trench has to be braced. And we hear pretty frequently about people either getting seriously hurt or killed in trench collapses.
Okay. When I talk to excavator operators, I talk about trench boxes. Is that the bracing? Just a trench box?
That's it.
Okay.
Just that steel rectangle that goes down into the trench so that the sides can't collapse. And what usually causes the collapse, in addition to unstable soil, is that there's usually that excavator operator, the excavator, which is very heavy, is sitting right next to the excavation.
Right.
And it just, the side of the excavation can't sustain the weight of the excavator.
Now, is there a certain depth that guys out there, they've got a small contracting company, they've got a guy running an excavator, there's a certain depth that you have to start looking toward implementing the trench boxes?
5 feet.
Okay. So if it's deep, if it gets as deep as a grave, you better have it supported.
Yeah. And one of my more tongue-in-cheek slides in my the presentation that I do actually is a grave digger who got buried in a trench. He was digging a grave and went down in the trench, and it collapsed on him.
Oh, wow.
So it does happen. There it is. Grave digger partially buried at Long Island Cemetery.
Okay. All right. Well, Mike, what else do we need to be concerned about? We've talked about the 4 ways they're going to come to our place, and we've talked about how we can comply. What do we need to is there a time when both TOSHA and OSHA could be involved in our site, so we got state and federal people involved?
That's probably not a likely scenario. It's either going to be a federally regulated site in a state program like TVA in Tennessee, which has a state program, or it's going to be all federal, like it would be in Alabama or Georgia.
Okay.
And then you get into these little situations where federal has jurisdiction in Tennessee.
Okay.
And TVA.
All right. So let's talk about you don't comply. All right. Now, so if you don't comply, or if you're found with a violation when someone comes in, we've already talked about the fact that there'll be a requirement that you do comply. So there's going to be costs There may be engineering costs, there may be equipment costs and the like, and certainly that's bad, but at least you're buying new stuff and you can use that daily in your business. Are there fines?
Yes, and again, similar to what we do in the environmental field, where we get a notice of violation or notice of noncompliance, citations issued, and OSHA or TOSHA will issue citations. By law, they have to be issued by certified mail within 180 days from the commencement of inspection, and usually it takes 3 or 4 months, and then a registered letter comes, and it will have citations, which will basically enumerate what standards were violated, and it's all standard based. So it's going to be, we responded, we looked at a situation, we saw that a standard applied, and it was not adhered to for the following reasons, and it will then give the specifics of what happened. And those standards all come with potential monetary penalties and gravity: serious, other than serious, willful, criminal. And those sometimes my clients are much more focused on the gravity than they are on the money, because if they're bidding work, especially in the construction industry, having a serious gravity citation on your record, which stays there for 5 years, and you go to OSHA.gov and put in establishment search, you can look anybody up. Those can debar a company from bidding work.
Also affects bonding, doesn't it?
Absolutely. I mean, all the way through. It's not a good thing to have a serious gravity citation. So sometimes at the settlement conferences, what we're talking about more than money is gravity. Okay. And if we get the gravity down, the money falls by statute. But just to give you an example, a serious citation up until last year was $7,000, up to $7,000. And serious has now gone to $12,400. And willful and repeat violations were $70,000. They've gone to $124,000.
So it can really get into the pocketbook and affect the viability of a lot of these small businesses.
Yes. So the Department of Labor's parting gift last year to employers was to say that they wanted to make up for the fact that there had not been any indexing or increase in penalties or fines since 1990. And they did a catch up.
Wow.
And I don't mean the condiment. I mean, they caught up, and they caught up in a big way. They almost doubled. And at this point, I can tell you, I'm looking at citations that are coming in right now for cases I'm working on where they're still $4,500 for serious. They're not $12,400.
And you don't want to point that out to the agency.
It's just interesting because the state program has not gotten there yet. Federal is there. And just because they can go up to that doesn't mean they will. They still give. It's a sort of a generous word to call it discounts, but for being a small business, for acting in good faith, and for those kinds of things, there are discounts that apply to penalties.
Well, I won't go the other way because we're almost out of time. You used a really ugly word. I heard the word criminal. Is there a criminal issue when you don't provide a safe work environment?
There can be, and I have been at the table at federal OSHA settlement conferences where the word willful criminal has come up, and it is not where you want to be, because suddenly, my goal is to negotiate a serious gravity down to other than serious. And when we're talking about willful criminal, then you're in a position where you're just wishing for serious.
And you can also take a violation that's civil serious, and by lying or by trying to alter the facts when the investigator comes in, it can go criminal. Is that true?
Yes. There are relators right now within OSHA that go to attorneys general and ask for criminal prosecution.
So if you've lied during the investigation, for example, if you say, well, we had all these safety procedures in place, but in fact, they didn't go into place till after the accident, that can result in a prosecution.
It can, and it will. And of course, we have one here that I can give you an example, which is a roofing contractor who lied about safety equipment he said was on site and it wasn't. And he was prosecuted criminally.
Okay. Mike, it's really been a pleasure having you. I've learned so much. The world of employee workplace and work environment is an area that a lot of our listeners don't know about. I hope it's been insightful to each of you, our listeners, and I hope you'll tune in to us again next week for Legal Bytes every Wednesday from 11 till noon, where we try to share with you some legal knowledge that affect your personal and business lives.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
Your marriage is over. You've been abandoned, betrayed. Your angry shaft